Good evening and welcome on behalf of Ketan and Co to all the participants. Good evening and good morning because we do have participants participating from different time zones. So, welcome all of you and gives us a great pleasure to bring this topic for discussion with the audience here. And I think, as many of you would have heard of the recent protocol that India signed with Mauritius, which really amended the treaty. And obviously, as a part of that, has created a lot of anxiety, to say the least, amongst a lot of our clients, fund clients especially, as to what this protocol really entails, how does this play out going forward, and many relevant questions as to what will happen going forward. And obviously, at this stage, we may not have answers to all, but I think it would be also an opportune time to really share some of our perspectives as a lot of clients are today anxious about their existing investments, proposed structures, and we thought it would be a good idea to really bring our experts, tax experts here who have been busy to say the least, post this notification, advising clients on some of these issues. So I think the fund industry has obviously used Mauritius, and at some level, if you may look at it, it has been one of the most used tax treaty amongst the funds industry ever since the treaty got entered into in 1983. I think really the opening up of the Indian market kind of really prompted a lot of the players to start exploring options when they were investing in India, more so to kind of mitigate what we call double tax risk for many investors because of differing rules between the jurisdiction of pooling and where they were investing in India. And it served a very significant purpose of facilitating foreign capital into India. So very clearly, I think Mauritius has played a very significant role in the growth of the fund industry in India, and has been a strong supporter even from a geopolitical perspective for India. Obviously, we've seen some of the ups and downs on the treaty over the last several years, and that's where I would say it is a treaty which has been most tested, if not challenged, but definitely tested on many grounds, and which is where I think this protocol it becomes very important to really understand the implication. So obviously, with that, I would like to invite our two panelists here, and just as a very quick introduction, I think Bijal Ajinkya and Rahul Jain are the partners in our tax practice. Bijal, as many of you may know, she has obviously been a very renowned tax practitioner, especially amongst the fund clients. And I think her real feather in the cap was the Azadi Bachao, which is what kind of the tax ruling which had settled a lot of questions around Mauritius under its old avatar of treaty. And obviously, she has seen the evolution of that treaty. So I think you couldn't have found a better person to kind of talk about this protocol and its implication. And I'm sure she will have some interesting perspectives to share. And joining her is our tax partner, Rahul Jain. I think many of you may also be interacting with him. He's our guy on when it comes to setting up of funds or structuring. So he's obviously someone who has been very actively involved on setting up of the funds, including those set up in Mauritius, and more recently also many of the relocations that we have seen out of Mauritius. So I think you couldn't have got a better kind of panelist here to share their perspective. We obviously want to keep the discussion as interactive and relevant for all of you. So we have a short presentation of about 10 to 15 minutes, laying down the landscape of what this protocol covers, followed by some questions that I would want to throw to the panelists here. But we also want to leave enough time for the audience to kind of raise any questions that they may have. And I think we've already, you may post the questions on the chat box, and we'll try to cover as many of those that we can. So with that, I think would like to hand it over to you, Bijo. I think, and maybe if you can walk us through the presentation between the two of you. Over to you, Bijo and Rahul.
Sure. Thank you so much, Siddharth, for the wonderful introduction and for laying the background of this very exciting journey of the India-Mauritius Treaty. Next slide, please. So as we really go, on the background of the treaty, and of course, we've all known of the Mauritius saga. In the 80s, we've seen the India-Mauritius tax treaty really being entered into, with the main aim to really look at investments into India. And all of us really know that Mauritius has been used as a pooling vehicle for really having investments made by US investors, European investors, Asian investors into India itself. The treaty really served a great purpose of ensuring that the Indian economy was really fueled with capital to ensure growth, provide employment, and to really provide that much needed churn to the economy. Over the years, we did have situations wherein the question of the applicability of the treaty was questioned, which is where the Central Board of Direct Taxes, by way of circular number 682 and 789, they rolled out a circular to essentially say that if Mauritius has issued a tax residency certificate to a particular entity in Mauritius, then India must respect the residency of that particular Mauritian taxpayer and to provide the benefits of the India-Mauritius tax treaty. Very, very interestingly, the circular went on to say that this not only looks at the residency of that particular taxpayer in Mauritius, but also considers that Mauritius investor as the beneficial owner of any income which really arises from India. It's very, very interesting to really see that a tax residency certificate has not only vouched the residency, but also the beneficial ownership of the income of that particular vehicle. There have been questions raised on the entire applicability of this India Mauritius treaty, given the fact that we had a lot of investments into India via the Mauritius route. And in October of 2003, the Supreme Court of India, in the case of Azadi Bachao, has very clearly certified that the CBDT Circular 789 is absolutely valid and kicking. And to that extent, if there is a tax residency certificate issued by the Mauritius revenue authorities, it must be respected as a sovereign country who's really issued that particular certificate. And India is not in a position to really challenge the same. Very interestingly, post this, we've seen a lot of investments really come into India. And in the year 2016, which is when the entire world was really looking at as to whether shell companies as well as tax abuse or tax fraud should be really considered or allowed. And according to the BEPS movement, India and Mauritius renegotiated the treaty to provide for not only a grandfathering of investments done up to March 2017 to ensure that the promise which foreign investors invested into India via the Mauritius route is really given sanctity to and therefore grandfathered. And to that extent, investments made post 2017 were really within the Indian tax net. Just around last month, very interestingly, without there really being an announcement, suddenly we saw this particular protocol on the government website. Interestingly, it's not there anymore. So it has been pulled down after a lot of noise really being created about the uncertainty in the way the circular has actually been, the protocol has actually been drafted, which essentially said that there is going to be a principal purpose test which has been introduced in the tax treaty. It is yet not notified by both the governments, or rather by any of the governments so far, and this protocol in itself has led to a lot of questions. Moving on to the next slide, we will now look at what really is this protocol? Why is this noise? Why has there been so much uncertainty? And what has been the real reason as to why this protocol actually had to be pulled out from the government's website and to ensure it really comes into the public domain only after there is much more clarity on the execution of the protocol itself. So, Rahul, over to you. Very interested to know as to what do you really see the protocol as and what has it really changed?
Sure, Vijay. Thank you. Uh, so the protocol, as Vijay just mentioned, was signed in March 2024, and it's been available for a while now, Vijay. Protocol is very short, the shortest text of law that we have seen, so far. But it does create, a little bit controversy, of course, right? Um, Very summarily, right? Protocol targets two things. One is it goes to the heart of the purpose of the treaty. uh, and as we just discussed in the previous slide, the treaty was signed in 1983, and the objective was to encourage mutual trade and investment and to avoid double taxation, of course, right? That objective has remained consistent so far, even after the protocol in 2016. But what this protocol seeks to do is it basically eliminates the objective of encouraging mutual trade and investment and seeks to replace it to say that while we agree that the treaty is to avoid double taxation, at the same time we don't want that there is double non-taxation or a reduced taxation through tax evasion mechanisms, right? And they have categorically said that a treaty shopping mechanism where the treaty benefit is intended for the residents of a third jurisdiction, that is also one of the mechanism they consider as a tax avoidance or tax evasion, right? Now, therefore, what does that mean, right? For example, a US-based group setting up one entity for holding one investments in India, is that a treaty shopping mechanism, right? That's a question to be asked, right? So that's the whole genesis of what the preamble of the treaty would look like going forward once it is notified, right? Then
And what is important to really look at here is that by deleting the entire objective, wherein, the objective of essentially having, to encourage mutual trade and investment, a particular objective which was really cast in stone by the Supreme Court in the case of Azadi, which essentially said that look, if two treaty partners have put this as an objective, to encourage mutual trade and investment into India, tax is a very small, insignificant part in the government's policy to actually encourage investment, and to that extent, it must really be given credence to. By removing this particular provision as an object and purpose in the treaty, it is in a way really negating the real reason why this treaty was really entered into. Very interestingly, this provision which they are trying to add, reduce taxation through tax evasion or avoidance, it's so unique, which is not really present in any other protocol or treaty in any other country. If we really look at this particular provision which is going to be added, if at all it really sees the light of the day, is there a difference between tax evasion and tax avoidance? Is not tax avoidance, within the four corners of law, so long as tax planning is really permitted, is not a taxpayer allowed to arrange his affairs in a way which gives him the best tax result? And to that extent, all of us know that taxes which are paid in the home country is our obligation, while taxes in a foreign country is a cost. And to that extent, having such a broad language really provided is going to lead to a situation wherein it could be used in a very negative fashion, wherein it could be questioned by the taxman as to is every transaction of an investment a case of a tax avoidance. So it's going to be very important that this particular provision is really recreated and redrafted so as to avoid unnecessary litigation in a situation where this particular provision actually is carved out.
that's right, Vijay, and I think that reminds me of the good old debate on tax planning versus tax avoidance, and that seems to be coming to the fore. Um, you know, maybe let's moving on to what is the heart of the protocol, right? The principal purpose test, and akin to general anti-avoidance rules under Indian tax law, but a more I would say dominant version. It basically means that if any of your principal purpose of a transaction or the structure was to claim India Mauritius tax treaty benefit, such treaty benefit could be denied, right? Now, what that means is if you're setting up your affairs with the dominant reason being to claim the India Mauritius tax treaty benefit, this principal purpose test will seek to deny those treaty benefits.
Very interestingly, Rahul is, providing this word dominant purpose, right? And when we really look at the dictionary meaning of what is principle, principle essentially means the main or it means the dominant. And when you really look at it, can there be more than one main? So, main, by the very clear definition, when you look at any dictionary meaning, means a dominant, which essentially means one purpose. And to that extent, when you're really providing a principal purpose test, which is of course there in any sort of a multilateral, instrument which is entered into by any country, can you really have more than one principal purpose, which is going to be a big question mark when you're really looking at applicability of these provisions.
Yeah, yeah, and this is, of course, this is coming out from the multilateral instrument, which is an OECD measures introduced to tackle tax avoidance mechanism under the tax treaties. While India, Mauritius have not signed the MLI, this is the provisions are similar, right? In kind of verbatim, if I were to call it for principal purpose test, and therefore, the way there are no precedents on what is the principal purpose test, there are no precedents on GAR as well, right? So therefore, we'll have to look through on how tax authorities interpret it, how courts look at it, right? Um, moving on to
And I think here it's
yeah,
very interesting to see that just, yeah,
No,
sorry,
go
it's
ahead,
very
Vijay.
interesting
I had
to
some
see
quick
that just
observation.
Sure. It's very interesting to see that just last year, in the year 2023, in India, we had judicial precedents as high of up to, 13 or 15 vis-a-vis the India-Mauritius tax treaty, wherein it was very clearly laid out by the judiciary in favor of the taxpayer to essentially say that if there is a tax residency certificate, we must honor the residency of such a vehicle and give the benefits of the India Mauritius tax treaty. And just fast forwarding 3 months later, we're really seeing a situation where you're, in a way, overturning that particular, those positive really rulings, which have provided the much needed confidence to foreign investors investing into the country.
Yeah. And I think just a couple of quick observation. I think the change of the purpose of a treaty. I think the way I look at it, it seems to be at the heart of the issues. To say that the erstwhile objective to encourage mutual trade and investment being omitted in many ways, I mean, it raises the question of is India really now using its economic strength or power to say that the purpose for which the treaty was entered at that point no longer holds valid, and to a great extent a question would arise that yes, we today still remain a recipient economy from an FDI perspective. But I guess as we globalize more, maybe there may be situations, and especially we've seen in some instances like outbound investments into Africa, and Africa is obviously the next big market and emerging market. I think and we are already as a country a significant stakeholder in many ways. I mean, obviously that may also raise this question when we are amending the objective. When we look at outbound and use of Mauritius at that point, may obviously again lead to the question of whether Mauritius needs to give any benefit to us, obviously, and then whether that would have some bearing on how people kind of really look at this protocol. Because I think it seems pretty interesting to, and I don't know whether this kind of deviates from any of the other treaties in terms of its purpose and objective. I mean, I don't know if we have similar purpose in all other treaties, then whether Mauritius is being singled out through this protocol to remove that purpose. I think that would be interesting, and I'm sure a lot of jurisprudence on this really would evolve. I think when, as and when the protocol, if as and when, I mean, I think we would still want to put an if there, but yeah, I think that's interesting. Sorry, I think over back to you, Rahul.
Yeah, yeah. No, I was just talking about, and so that, I mean, just on that mutual trade and investment, and that's a salvage when you look at the exception which they provided to principal purpose test, that
Mhm.
it should not apply so far as granting the benefit is in accordance with the object and purpose of the relevant provision of the treaty, right? Now, on one hand, you're saying my object and purpose is to, avoid double non-taxation and reduce
Mhm.
taxation, and at the same time, you're saying that we will give you the benefit so far as it is in accordance with the object and purpose. So again, maybe something for the professionals, the advisors, and clients to explore and see how to make best use of it, and because that's an exception to PPT. But of course, we'll see at how things play out. Maybe the only difference is it says referring to the relevant provision of the treaty. So to my mind, if you were to look at a dividend income tax article under the treaty, which says that dividend is taxable at 5% for a Mauritius resident company, which holds at least 10% in the Indian company, and which is the beneficial owner. So if a Mauritius entity is meeting all these four tests, right, then it is in accordance with the object and purpose of that treaty, of that provision to give you that benefit, right? What else could I have shown? Right. So maybe that's kind of debate and discussion and deliberation we'll need to have once we move forward.
Yeah, we
But
can actually
Absolutely.
write a book on,
yeah,
how do you look at the interplay of the object and
yeah,
purpose. You could have set up a vehicle like say 15 years ago or 10 years ago, right? And at that point in time, the object and purpose was to encourage mutual trade and investment, which is where a lower tax or an exemption was actually provided for certain streams of income. And suddenly you changing that particular object and purpose is really negating the entire reason and the confidence with which an investor has actually set up a vehicle in Mauritius.
right,
So it's going to be very interesting to see as to how the interplay is. But of course, given the fact that Mauritius has really been the highest contributor to foreign investments into the country, I would definitely feel that the government will stand and honor its promise to actually ensure that there is no sort of a litigation surrounding something like this.
right.
I think now we should move to effective date, Rahul.
Yeah.
And when is this protocol really going to be effective?
So going by the literal reading of the protocol, it says the protocol is effective from the date both the countries notified, which will ratify, complete their internal procedures and notify it, and whichever is the later date, that is the date on which the protocol comes into effect. What is interesting is this added language, which has caught the attention all over. It says it enters into force once both the country notifies it, but without regard to the date on which the taxes are levied, or without regard to the taxable period to which such taxes relate, right?
Mhm.
The question is, what does it even mean? So that's the first question. Now, are you saying that do I need to look at past period? Uh, how does it play out? It is in what context, right? One interpretation, or not the interpretation, I would say, but um, one
Way to
reading
read it.
is that does it mean it applies to past years, right? And that's the whole area of concern, that can it apply to past years? Is it a retrospective amendment, right? Um, so far, what we've seen, tax treaties, retrospective amendments have been rare or kind of not be
Not
there,
really allowed,
right?
yeah.
Under Indian tax law, Siddharth, we've seen this government has said we are averse to making retrospective amendments, right? We are not looking forward to it. Now, therefore, and because of that, UN CRI, the Income Tax Department did issue a release saying that the concerns are premature. We'll issue the clarifications if required, but don't just go all over it and say that it applies retrospective, right? So therefore, I think, and of course, it has far-reaching impact. It goes back to the government circulars that were issued. It goes back to our favorite ruling of Azadi Bachao Andolan, and that's something which
Yeah.
you would not expect both the jurisdictions to do.
Absolutely. And what is very interesting to see that this particular language, which is highlighted here without regard to, It's mentioned in tax information exchange agreements, vis-a-vis information sharing between countries, which is what we commonly call as TRs, with respect to tax avoidance and tax frauds. And it's in treaties with respect to tax sharing of information. In no other treaty wherein you're trying to bring in a principal purpose test do you actually have this particular language. So is this particular mix which has been done being done intentionally? We would generally believe that it was not meant to be retroactive. We would read it in a positive light, which is where they're really trying to provide that clarification. The question really arises that was this particular language really required? Why could we not just stop at the fact that, post ratification, it is going to be effective? And this particular language has been a major cause of concern, giving sleepless nights to fund managers as to whether their past concluded transactions, whether income has arisen prior to, whenever the protocol is going to be in effect, are now going to be reopened. Moving on to the next slide, let us now, Prajay, can we move? Yes. Let's really look at where the controversy is and why is this retrospective, reading of the effective date. When is it going to lead to a clash in the tax treaty itself?
Right. And the whole discussion, Vijay, on effective date, non-effective date, and basically how to take a cue from. If you look at the previous protocol that came in 2016, what it sought to do was, it of course said that capital gain on sale of shares acquired on or after 1st April 2017. Now the taxation right is with India also, but at the same time it grandfathered the investments prior to 1st April 2017. And it was very clear that while we are entering into this protocol, we are amending the tax treaty to allocate the taxation right on sale of shares in Indian company to India until the date this protocol comes into effect. For the investments you've done prior to 1st April 2070, the previous provision still apply. That means the exemption still applies, right? And you also had a press release issued by the government of India to say that the investments are grandfathered prior to 1st April 2017. India Mauritius Tax Treaty does not seek to change the status quo on that, right? And so on one hand you have that protocol which was again signed by both the jurisdiction, and now to say that this protocol applies retrospectively is a far fetched to some extent.
Yeah. So let us look at a situation where this could actually have an application. So if we have made an investment until March 31st, 2017, what the 2016 amendment gave clarity on, that irrespective of when you sell this particular investment, there is no question of there being tax in India on the capital gains which have arisen. Now, by having this protocol, of March, 2024, whenever it actually gets passed, if it does get passed in its current form, what it is essentially saying that yes, we are going to be prospective. Let us assume it's going to be prospective and it's not reopening, the past transactions. But let us look at a situation where I have made an investment on March 20th of 2017. By this 2016 amendment, irrespective of whenever I sold it, I did not need to have, any sort of a substance or a commercial justification to be in Mauritius. And whenever I sold it, I was supposed to be exempt from Indian capital gains tax. Now, by this particular MLI, by this particular protocol, on having a principal purpose test actually, signed in, what you're really doing is you're watering down this particular 2016 amendment, which will essentially mean that you have an MLI provision, which is essentially saying that if you do not meet the principal purpose test as to what was your main reason or your principal reasons of being in Mauritius, irrespective of whenever you have invested into India via Mauritius. So you could have had a May 20th, 2017 investment. If you don't meet the principal purpose test, we do not care about your grandfathering provision. We are going to provide a tax. And to that extent, it will be great for the government to actually enter into some sort of an MOU to remove this particular friction in the tax treaty in itself, to say that, look, it was a promise to provide a grandfathering for investments made prior to March 31st, and we are going to keep that promise. We are not going to be in a situation, or we are not going to have taxpayers in a situation where 6 years later you are by a backdoor entry of providing a principal purpose test, removing this grandfathering provision. So it is very, very important that this particular clarification is provided in order to ensure that there is a clarification on how grandfathered investments are going to be seen to be taxed.
That's true. And if we can move to the next slide, let's talk about how India has unilaterally also accepted.
Next slide, please.
Yeah.
Thank you.
So how, and this is the car provision as we know under Indian tax law. Fortunately, has not been invoked yet. But if you look at it, what it says, right? GAR was made effective from 1st April 2017, but the government of India was mindful of the fact, right, that it cannot be applied retrospectively, and hence it clarified that all the investments and transactions that you've undertaken prior to 1st April 2017 are grandfathered and therefore not subject to GAR, right? Now, on one side, you have India saying unilaterally that we don't want to apply GAR to pre-17 investments. Now, therefore, the question is, can you apply the PPT to pre-17 investments, right? Um, and a counter to that could be, or an answer to that could be, Vijay, India and Singapore, India with other countries have entered into MLI provision. It's that, and MLI is a pet project of OECD, which seeks to inbuilt in the same principal purpose test where you both the countries have agreed to the provisions. Therein, there is an effective date provided in the MLI generally that it comes into effect for the taxes in relation to transactions completed on or after 1st April, for example, 2020, right? Let's say the MLI is effective in March 2020. The provisions will say that principal purpose test applies to taxes in relation to transactions undertaken or after 1st April 2020, right? Now, if you were to draw an inference from that, and while India, this is a protocol, this is not a treaty, and we are debating on what is the effective date. One argument could be that though the investment was made pre-17, there is a chance if you were to look at MLI, it could apply to those investments if you were to sell it after the notification date. Yeah.
Okay.
Moving on to the next slide.
Yeah, and this is what we were discussing, Vijay, briefly, that India has entered into MLI with Singapore and in some of the key treaties, right? And maybe best to talk about Singapore because that has been generally coterminous with Mauritius. Singapore was in a way following Mauritius some time back, but it acted as the fourth. Now it came in the front, and they said no, we are signing an MLI with India, and we are building in these provisions into our treaty. So if you were to look at from just to draw a comparison, India-Singapore Treaty also says that if your capital gain arises from investments undertaken prior to 1st April 2017, it is not taxable in India. But now your PPT test is applicable. So if you want to do a sale now because of the MLI, you need to test the principal purpose provisions, right? Now, and therefore you are drawing a comparison on whether Mauritius can also be analyzed on the same lines. Answer depends on how you read it and how what the government clarifies because India Mauritius is not subject to MLI. It is a protocol, and protocol has to be read in the way it is drafted, right?
And what is important to always note here is that though domestic tax law or our income tax act tax provisions need to be having a strict interpretation, when you're looking at any tax treaty which is a contractual arrangement, you do need to give it a more purposive interpretation. And to that extent, the promise of the treaty partners does need to be kept in mind. And to that extent, we must really look at more creative thinking as to how this treaty must, or this protocol for that matter, must be really interpreted, especially the principal purpose test.
That's right.
Yeah. Next slide, please.
Okay. Maybe we can spend some minutes on this, and Siddharth, over to you on, how do you look at it?
I think,
What questions you have?
yeah. So I mean, I think obviously this is I mean, in some sense, fascinating as to how we seem to be bringing back the ghost of retrospective amendment having come out of those issues. And I think after all those assurances, I also feel maybe in many ways, I don't know whether this protocol, and I think it was completely kept confidential in many ways. So it took everyone by surprise, as I think Vijay pointed out. But I don't know. I mean, I think it's definitely raises a question as to whether Mauritius negotiated its position and whether it was in a position to negotiate its position as kind of strongly, because I think it definitely seems to be going to the heart of the treaty, and in many ways can definitely have a far-reaching impact. At the same time, I'm quite hopeful that the government will take a lot more pragmatic view and also respect the decisions taken by the investors, investments in terms of grandfathering. I mean, today raising a question on an investment after having given the grandfathering, which was probably where the industry, fund industry as a whole came to come to grips with that 2017 is the sunset, and then obviously post that. So there was at least an ability for them to plan themselves with this, and then grandfathering gave a lot of comfort. I think an open-ended provision around in the protocol like this, what is proposed, I think it can definitely lead to the same concerns coming to fore. And we do hope the government will act more reasonably on it, and maybe at some point, as we all know, I think in India it's really the judiciary that ultimately sets the tone. And I think some of these principles of whether grandfathering can be overridden through this, or whether the principal purpose test can be used for investments which were made prior to the 2017. I think we do hope that some of this does get clarified rather than having to leave the investors in lurch for a long time, creating a lot of uncertainty. And I think that's what the treaty was at least supposed to address, remove uncertainties. The regime has been developed over a period of time. A lot of groundwork was done by the government and policymakers in trying to build a both tax and protocol kind of starts raising some questions around that. So we do hope that there will be some clarity that may emerge out of it as we go along. And I think a lot of questions, as I think both of you have raised, very pertinent ones. And then I'm sure with that, maybe I think just a quick few questions before I think we are getting some questions from the audience as well. But maybe I think, Bijal, I mean, in terms of, I think we've talked about the protocol and what could be the potential interpretation, but looking at it purely from a fund industry perspective, I mean, what do you think is really the impact, and to what extent that the clients or fund managers need to really kind of factor this into their planning for their existing investments to start with, and then any advice that we would typically give for our clients on that, on fund clients.
Yeah. So I think, one important point to really note is that, bringing in this principal purpose test is something which was absolutely expected. It was only a question of time because the world today, in tax matters is really moving, to actually bring in that principal purpose test, which is, now present in many other tax treaties. The question really is more with respect to, on the one hand, you have grandfathering, on the other, you actually introduce a PPT. So it is important that there is a clarification on that. what it really means to, the fund industry, I would feel that, the industry is very uniquely placed because more often than not, the reason why Mauritius has been really used is to ensure that you require one country to really be a pooling country, a pooling jurisdiction wherein all investors are really investing into so that you have the pooling availability. Really,
Hmm.
when you look at the administrative strength of Mauritius, the manner in which it is such a well-oiled machinery to have fund administration set up out there, a strong bilateral investment treaty with India, there are many, many reasons as to why we are really seeing funds really set up in Mauritius. Interestingly, we've also seen that post 2017, which is where the entire India, the capital gains tax exemption was in any event taken away. Even post that, we have seen many funds really being set up in Mauritius. There has not The main purpose has never been tax because there is no tax benefit. So it is very important for every fund to be in a position to actually carve out what was the principal reason as to why you were set up there in a situation where there are grandfathered investments, to be in a very strong position to say that, look, tax may be an incidental benefit which we may have got, but the main purpose or the main reasons why we were really set up there were multifold, be it pooling, be it having a strong center which has administration as an offshore center, and so on and so forth, and of course to avoid multiple levels of taxation. And that's the way in which the
Hmm.
global industry is really set up. If we're looking at indirect transfers, which is where the entire, there is no grandfathering available there. And to that extent, even today, under the India Mauritius Tax Treaty, is allowing for indirect transfers, which essentially means if we have a Mauritius vehicle, having invested into another Mauritius vehicle for investment into India, there would have been a specific rationale as to why a second level of a Mauritius vehicle has been interjected there. And if at all there is going to be a transfer undertaken at that second level Mauritius vehicle, very important for it to be documented as to why we are really looking at an exit at that level. So long as those particular reasons and the principal reasons why you are really looking at an indirect transfer are documented, we have yet a very strong case to ensure that the availability of the tax treaty exemption is provided for.
Yeah,
I
and just
think
to add,
you,
Siddharth,
yeah.
practically, even today, when you're looking at funds getting assessed by the tax department, the notice does talk about all of these questions, right? So they'll ask you everything and anything under the sun, right? So they are familiar with it. They know what questions to be asked. They're asking the details of the parent company. They're asking you where you're situated. They're asking you where your control and
Hmm.
management lies. So all sorts of information. And the funds have been successful in getting those reliefs after appropriate justification. So to my mind, the issue and the justification is still there. It's just that we need to be more, and department will just take the shelter of the principal purpose test to make it more stronger. And at the same time, clients will have to make their explanation more robust, right? And like Vijay mentioned, that have the documentation, strengthen the documentation as well.
And I would also
Hmm.
add on here to say that, we do have an India Singapore treaty which already has the principal purpose test since 2020. And it's been 4 years. You have had assessments which are completed so far. And very interesting it is to see that it has not been a case where the principal purpose test has been misused by the tax authorities to really bring to fore any sort of a transaction to tax. So of course,
Hmm.
as anti-abuse, when you're looking at the general anti-abuse provisions and really the rationale amongst countries to have a general anti-abuse provision in a domestic law, which is very relatable to a principal purpose test under a tax treaty. It is not a case that every sort of a tax planning is supposed to be struck down. It is only in situations where you are leading to a tax fraud or a tax abuse, which is where a principal purpose test or a GAR is a weapon to strike down tax fraud. So let us never misunderstand a principal purpose test or a GAR as an end to tax planning, but we must
Mhm.
really ensure that a tax benefit is only incidental to any sort of an arrangement, and our main purpose must be some other commercial rationale.
Understood. And I think maybe as a part of your discussion, you may have answered one of the question that came from the audience in terms of indirect transfer and whether selling the assets outside India, which is basically deriving its value from Indian assets, and then they are technically not covered under the India-Mauritius Treaty, and whether these will now get covered by virtue of this protocol. I think that was one of the questions. And what I
Absolutely.
understood that maybe this should not really extend to indirect transfers, at least. Is that a fair understanding at this point? Obviously, uh, one needs to assess it as and when the jurisprudence evolves. But any thoughts on that?
Right. So, whenever this particular protocol is effective, right,
Hmm.
as Rahul mentioned, whenever the both countries actually comply with the domestic procedure to ensure that the protocol is in effect in their respective country, vis-a-vis indirect transfers also, the MLI will apply. And the MLI in the sense of the principal purpose test. And it would be extremely important to document your commercial rationale for the two-tier structure as well as your commercial rationale for an exit at the top tier level to have an
Hmm.
indirect transfer. So long as that particular commercial rationale has been documented and provided for, it would be a strong reason to ensure that tax treaty benefits are still available.
Understood. I think also there's a very interesting question, and I would say it's more in the nature of observation, but kind of touches upon one of the discussion point that we had, GAR versus the PPT. And one of the question was, I think from the audience, I think has been that India had already renegotiated the treaty, and the primary benefit of capital gains was obviously taken away. And obviously following that, we also had introduced GAR under the domestic law itself, which obviously provided for overriding the treaty benefit where the structures were meant to be seen as GAR non-compliant. In that backdrop, I think obviously a question comes up. I mean, was there really what is being achieved through this protocol, through and whether such a harsh or a protocol with a lot of uncertainty was really a necessity at this point, or I think that and it's a valid question that does this kind of add more than what GAR had already empowered the government in terms of looking at structures or denying treaty benefits if these were found to be lacking substance. I don't know if any thoughts on that.
No, very interesting question here, Siddharth. And, I guess, from a government perspective, bringing in the principal purpose test, either by way of a protocol or by having an MLI or a covered tax agreement, is something which was a dicta and was an agreement amongst countries around the world. Because we were
Mhm.
looking at a situation where the OECD, through its BEPS movement, was trying to avoid or to shelter situations of tax abuse and to ensure that each country has its fair share of taxes. So I would say that it was very obvious that at some point in time, the principal purpose test would have crept into the tax treaty. But what is very important to really see, and generally we would always say that the provisions of a tax treaty are more favorable. However, when you have an anti-abuse provision under the general anti-abuse provisions under the domestic law, and you have an anti-abuse provision as a principal purpose tax in the tax treaty, it's very interesting to see that the GAR provision is somewhere providing you many more checks and balances, wherein not only there is a monetary threshold of a 3 crore rupees, so the tax authority can actually pull up something on the GAR front only if the tax benefit is higher 3 crores. So, somewhere it's a check and balance. Secondly, a tax authority does need to go to an approving panel before it actually tries to bring a particular transaction within the GAR framework. Now, when we look at it in the parallel, under the principal purpose test in the tax treaty, there are no checks and balances. And to that extent, there is a free hand, and it's going to lead to much more uncertainty vis-a-vis a principal purpose text being invoked under a tax treaty. Also, very interesting to note that the general anti abuse provisions are looking at a situation only where the main purpose of a particular arrangement is a tax benefit. While, on the other hand, the manner in which the protocol is really worded is if one of the principal purposes is a tax benefit, there is an issue. So if you really look at the GAR is at a main purpose, which essentially looks at the primary purpose as to why you have, structured a particular transaction. So while in the principal purpose test, it's any one of the principal purposes, which is going to be very difficult to say that what is the meaning of one of the principal purposes. So very interesting. Generally, a tax treaty is always considered more favorable, but in this situation, I would say domestic law in GAR is actually more favorable. We've often been asked a question that, you have Section 90 in the Income Tax Act where a taxpayer can choose to be governed by
Absolutely.
domestic law or a tax treaty. The question which really arises is, can a taxpayer tell a tax authority that, look, don't have me governed by an PPT provision under the treaty. We want to be governed by the guard provision. So, unfortunately, not, because that is their weapon. That's not a weapon available to a taxpayer. But it would be interesting if, at all, that particular weapon was also available to a taxpayer itself. So, it will be important for over time there to be some clarity as to how we are really looking at PPT. Is it going to override guard provisions? Possibly not. That was not really the intention. But at the same time, we must essentially share with you that the manner in which principal purpose test is worded in the India Mauritius Treaty, it is worded in almost the same fashion in any other tax treaty. The only real difference is in the manner in which the effective date has been mentioned, as well as the change in the object and purpose. So, to that extent, given the fact that foreign investment into the country is of primary importance, we would believe that the government will essentially ensure that we are not really taking away that particular goal by having this protocol, in this particular manner.
Yeah.
Yeah.
I mean, I
And
think
Vijay,
it's
like we were
it's going to
discussing,
be.
yeah, no,
Yeah. Go
Siddharth,
ahead. Go ahead.
just to complete, Mauritius has, ratified almost 2025 tax treaties for MLI, right? So it's not that Mauritius is kind of averse to MLI. They have, for policy reasons, maybe India is not notified yet, but no country in today's world where OECD is trying to bring all countries at par and to eliminate tax havens want to be seen as supporting tax avoidance or tax
Of
evasion,
course.
right? And that is one of the reasons why this protocol has been brought into place, right? So yeah, why they have
I
put
mean, I
in?
think.
Because it does apply. Yeah,
Yeah. And then I think it's going to be very interesting as I see it, the overplay of PPT and GAR, and as I think Vijay rightly pointed out, I think even when GAR came, a lot of questions came about will it kind of put uh, uncontrolled powers in the hands of the assessing officers and have to question every transaction. And then we evolved a protocol and some conduct where I think comfort was drawn that there will be a process followed. And as you rightly said, by now, including a PPT in a protocol here and in the treaty, are we again leading to a situation that every assessing officer now is getting empowered to kind of question structures and all under the principal purpose test without going to the guard proceeding. So I think I do hope if we have some of the policymakers listening in, I think there would be an important kind of alignment that would be needed here. And I think we do hope that the government will kind of really try and address this, because it could really lead to unnecessary litigation. I think in some sense we had come a long way over the last few years, when with the retrospective amendments being not undertaken by the government. They tried to cut down on litigations, all of that. And now you suddenly have a protocol which is kind of putting unbridled power in the hands of the assessing officers to start questioning this. So I think it's going to be a very, very interesting times. I mean, it can be frustrating for us as practitioners, and I think we have a question here which seems to be hitting the nail on its head. And then someone, I think from one of the advisors here, I'm keeping the names out for now, but the question is, they are in the midst of a transaction and they are on the sell side, and the buyer is now asking for an opinion on PPT, and to what extent would this be applicable to a transaction, and whether this kind of, I mean, I think obviously the simple answer I would say is it's yet to be notified, so not effective. But I guess it's already laid down the ratio in many ways. So I am sure as a buyer, you may think things very differently now that it has been spelled out in a certain manner. So, and then with the uncertainty around retrospectively applicable. So I know, I think we are also running out of time, but maybe I think one last couple of questions, Bijal. I mean, your thoughts on, is this the end of the road for Mauritius as an offshore finance center, and as far as India is concerned? Or you think that, as you said, it's a development which is driven more by the global kind of standards being prescribed, and hence it does not kind of really put Mauritius at a disadvantage compared to maybe other treaties? So, I mean, any thoughts around that?
Yeah, so I would say that the principal purpose test was bound to actually come into the tax treaty at some point in time. The reason why there is so much talk about it is because Mauritius has really brought in the highest amount of foreign investment into India. And the uncertainty around it with respect to certain interpretations regarding its entry into force has really created those particular questions. Today, it is not a situation after the 2017 amendment wherein there is any sort of a tax benefit of investing into India via Mauritius. However, we have seen post 2017 a number of investments come into India via Mauritius, and it's very clear that the tax which you're paying in India is just considered a cost of really conducting that particular transaction, or it's a cost of really making an investment to get returns. So I would not say that it's going to be the end of Mauritius. It's always going to continue because it's a well-oiled machinery. It's a familiar jurisdiction, and to that extent it does have that level of reputation amongst offshore financial centers. So it's not really going to be a much of a change. I think what is important to really consider is that in situations where we are considering some benefits to really be availed under the tax treaty, you know vis-a-vis say a dividend withholding tax, either at a 5% or a 15%, under the India Mauritius tax treaty, as opposed to a 20% under the Indian domestic law. Or for that matter, if we are looking at uh, interest withholding tax, which is currently at a 7.5%, very, very important that the reasons and the rationale for incorporation into Mauritius, as well as the reason why we are looking at the entire commercial justification around that, needs to be crystallized and properly documented. Once that is essentially undertaken, yes, there will be situations where you will see a lot of investments, even for earning these type of incomes really coming in. And to that extent, I would always feel that Mauritius is going to be a country which would really continue to attract investments for India, more from the perspective of just it being, a much easier jurisdiction, a closer jurisdiction. You're looking at situations where, they are used to the manner in which fund managers from the US or from Mauritius or from whichever part of the world are looking at, the entire administration set up in Mauritius. So to that extent, I would believe that it is going to continue.
Great. I think we are pretty much at the end of the hour, and obviously, we would not like to keep the audience waiting. I know it's late in the evening for those who are participating here, but Bijal and Rahul, I think thank you so much for sharing your thoughts. I think it's been a very, very engaging discussion. At least I think personally, I felt very interesting perspectives were shared on what this protocol, the background to the treaty, and probably some insight on how people should kind of plan their structures going forward. I'm sure there will be tons of questions going forward, and maybe the jurisprudence around it will evolve. But definitely for the audience here, I think we do hope you found some interesting takeaways from the discussion here. But if you have any more questions, please do drop us an email and reach out to us. I mean, we'll be happy to share some of our insights on that, and then definitely look forward to working together to make sure that your structures remain robust, and then obviously the regime kind of aligns well to and then at our end, obviously with the policymakers as well, there will be a lot more opportunity to engage. So we do hope some balance will emerge over a period of time. But till then, I think thank you once again, and we look forward to staying connected, and take care. Good evening and good morning to others in the other part of the globe. Thank you.
Thank you
Thank you
so
so
much.
We can
much.
close. Thank you.